Hey everyone, welcome back to documenting and exposing West Shore RCMP. This is part 7. In this video we're going to go through the criminal charge of mischief, and we're going to go through the Crown Counsel policy on charge approval assessment, as well as their policies and obligations of disclosure to the accused. So I am facing one count of mischief, and mischief is section 430 of the Criminal Code of Canada. And in Canada, mischief is one of those charges that's sort of broad, and you could be charged with mischief for a variety of things. So if the police don't really have anything to arrest you for or charge you with, this is one of their go-tos in Canada. Mischief. Subsection 1. Everyone who commits mischief, who willfully... And that's what I was kind of left with, wondering what I was charged with, because they never said A, B, C, or D. It was always 430 subsection 1. So I'm assuming they were going to go with D, which is obstructs, interrupts, or interferes with any person in the lawful use, enjoyment, or operation of property. That person, of course, being Arun Kundu-Thomsen, the watch commander at West Shore RCMP that arrested me for public photography on public property. And subsection 7 of mischief says that no person commits mischief within the meaning of this section by reason that he attends at or near or approaches a dwelling house or place for the purpose only of obtaining or communicating information. So let's have a look at the policy that Nicholas Barber of Nanaimo Crown Counsel used to approve this charge of mischief. Now, I've read a lot of this policy before on previous videos, so I won't read the entire thing from start to finish. I'm just going to read some of the more important parts that pertain to this charge approval of me committing a criminal offense of mischief and it getting approved. So let's scoot down to the third paragraph here. It says, the charge assessment function of Crown Counsel is also independent of the investigative responsibility of the police. Reasonable cooperation and effective communication between Crown Counsel and the police are essential to the proper administration of justice. However, Crown Counsel must guard against becoming too closely connected to the police or doing anything else to hamper their ability to conduct objective charge assessments. So we're going to skip ahead to this page here and go to the paragraph down the bottom half there, the charge assessment standard. As the necessary legal context for any charge assessment decision, Crown Counsel must consider the presumption of innocence, the prosecutor's burden of proof beyond a reasonable doubt, and the prosecutor's fundamental obligation to act as a, quote, minister of justice, unquote, and see justice done. In discharging the charge assessment function, Crown Counsel must independently, objectively, and fairly measure all the available evidence against a two-part test. Number 1, whether there is a substantial likelihood of conviction, and, if so, whether the public interest requires a prosecution. This two-part test continues to apply throughout the prosecution. So you can see here that's not doesn't just apply to the charge approval, it applies throughout the entire prosecution. Evidentiary test, substantial likelihood of conviction. Subject only to the exception described below, the evidentiary test for charge approval is whether there is a substantial likelihood of conviction. The reference to, quote, likelihood, unquote, requires at a minimum that a conviction according to law is more likely than an acquittal. In the context, quote, substantial, unquote, refers not only to the probability of conviction, but also to the objective strength or solidity of the evidence. A substantial likelihood of conviction exists if Crown Counsel is satisfied there is a strong and solid case of substance to present to the court. In determining whether the test is satisfied, Crown Counsel must consider the following factors. What material evidence is likely to be admissible and available at a trial? The objective reliability of the admissible evidence. Whether there are viable defenses or other legal or constitutional impediments to the prosecution that remove any substantial likelihood of conviction. So that's pretty interesting. They can only approve this charge, the first part that they have to consider, is a substantial likelihood of conviction, and they can only approve this charge if there's a substantial likelihood of conviction. So let's move on to the next the part of the test, which is the public interest test. And it goes like this. If Crown Counsel is satisfied that the evidentiary test is met, Crown Counsel must then determine whether the public interest requires a prosecution. Protection of society is a paramount concern of the criminal justice system. Justice does not require that every provable offense must be prosecuted. The resources of the criminal justice system are not unlimited. If reasonable alternatives are available, they should be pursued. Prosecution should be reserved for cases requiring the full force of the criminal justice system with all its available sanctions. In assessing the public interest, Crown Counsel should take into account the particular circumstances of each case and the reasonable public safety concerns of the local community. Hard and fast rules cannot be imposed. Crown Counsel should consider and weigh the following factors to the extent they are relevant in any particular case. Public interest factors that weigh in favor of prosecution. The seriousness of the allegations. The likelihood of significant sentence upon conviction. The seriousness of the harm caused to the victim. The use or threatened use of a weapon. And most of these don't really apply at all to me, but there's one sort of in the middle there. It says the alleged offender's history of relevant previous convictions or previous allegations that resulted in alternative measures. And on the next page here, just skip the top three. We'll go with the fourth one down. It says the presence of reasonable grounds for believing the offense is likely to be continued or repeated. The offense occurs frequently in the location where it was committed. The offense is one that affects the integrity, safety, or security of the justice system or its participants. The offense is a terrorism offense. The offense was committed for the benefit of, at the discretion of, or in association with a criminal organization. And here are some public interest factors that weigh against prosecution. So I'll let you read through these, but none of these really apply to my situation, even remotely. So we're just going to skip to the next page. Well, here's one that might apply. The alleged offender's lack of history of relevant previous convictions or recent previous allegations that resulted in alternative measures. The offense is of a trivial or technical nature. The law giving rise to the offense is obsolete or obscure. It's kind of funny. Kind of off topic, but the next one, this big long one down here, this deals with people that go out and catch child predators online and then videotape it and post it on YouTube or Facebook or whatever. I won't mention any names, but there's a lot of groups out there that do that now. And here's some policies saying that they can basically turn those down. That it doesn't. Basically, they're saying if people go out and do this, they don't have to approve the charges or take the case or take the evidence or anything. And number 3, public interest factors that may weigh either in favor of or against a prosecution. Don't really see anything here, but the middle one's kind of interesting. The personal circumstances of the accused. Oh, hey, here's a good one. The length and expense of a prosecution when considered in relation to the social benefit to be gained by it. Well, there we go. Ding, ding, ding. So the next one doesn't really apply, but the last one there says the need to maintain public confidence in the administration of justice. So I guess, do you guys have a lot of faith now and confidence in our justice system now that they tried to prosecute me for public photography on public property? And skip to the next here. Exceptional evidentiary test, reasonable prospect of conviction. And this one is hilarious, so I might be laughing through this, but here we go. In exceptional circumstances, where the relevant public interest factors weigh so heavily in favor of a prosecution that it is necessary to resort to a lower charge assessment standard in order to maintain public confidence in the administration of criminal justice, a charge may still be approved even though the usual evidentiary test is not met. Crown Counsel must exercise particular caution in such cases because of the nature or quality of the available evidence or the exceptional circumstances said to justify resorting to a lower charge assessment standard. For example, the gravity of the offense, the identity of the alleged offender, or the degree of public outrage about the offense could materially increase the risk of a miscarriage of justice. Under such circumstances, the minimum evidentiary standard, which continues to apply throughout the prosecution, is whether there is a reasonable prospect of conviction. A reasonable prospect of conviction requires more than just, quote, some evidence, unquote, on each essential element of an alleged offense, but does not require that a conviction be more likely than an acquittal. The term, quote, reasonable, unquote, means on reason, rationale, objective, as opposed to subjective. Quote, prospect, unquote, is forward-looking. It involves an expectation of a potential outcome informed by a previous experience and common sense. A, quote, reasonable prospect of conviction, unquote, exists if experienced Crown Counsel, informed of all the relevant facts, is satisfied there is a rational and realistic basis for obtaining a conviction according to law. In determining whether this test is satisfied, Crown Counsel must consider the following factors. What material evidence is arguably admissible and available at trial? The objective reliability of the admissible evidence. Whether the evidence is overborne by any introcontrovertible defense. In assessing the evidence, Crown Counsel should assume that the trial will unfold before an impartial and unbiased judge or jury acting in accordance with the law, and should not usurp the role of the judge or jury by substituting their own subjective view of the ultimate weight or credibility of the evidence for those of the judge or jury. Where Crown Counsel concludes that it is necessary to resort to the lower charge assessment standard in order to maintain public confidence in the administration of criminal justice, Crown Counsel must consult with the regional Crown Counsel or a director prior to concluding the charge assessment. Crown Counsel must ensure that the decision is noted on the file. So what do you think? They got a solid case here? They have a substantial likelihood of conviction? Does this prosecution, does it meet the public interest test? Is this really within the public's interest to prosecute me for public photography on a public sidewalk? If we just went through this policy and I mentioned something, you should really consider that. So I want to get very briefly into the Crown Counsel's obligations and policy for disclosures. And I just recently found this neat little thing online from the Law Society of BC. And this was one of the quotes I was actually looking for this video, and it's in case law, but I found it here, and it's pretty recent and relevant for today, so I thought I'd share this here. And it says here, while it may be expedient to make verbal requests for disclosure from the Crown, defense counsel should consider making a well-crafted written disclosure request. A complete and thorough written request for disclosure crystallizes some of the Crown's obligations. And the written request can serve as a very useful tool if disclosure issues arise as the trial approaches or during the course of the trial. And as you'll remember in the last update, part 6, I'd gone through 3 letters, well-crafted letters in writing to the prosecutor, Nicholas Barber of Nanaimo Crown Counsel, requesting disclosure, mostly of my evidence. So he's already got 3, not 1 request, not 2, 3 well-crafted letters. And we're going to finish up with the Public Prosecution Service of Canada here, the principles of disclosure. So one thing I found very interesting here is the last one here, 3.8, documentary and other evidence, where reasonably capable of reproduction, copies of or access to all documents, photographs, audio or video recordings of anything other than a statement of a person should be provided whether or not they are intended to be relied on by the Crown. where there exists a reasonable privacy or security interest of any victims or witnesses that cannot be satisfied by an appropriate undertaking from the defense counsel, Crown Counsel should seek to impose conditions by a court order. So all of the videos that I've asked for, I've written Nicholas Barber of Nanaimo Crown Counsel 3 well-crafted letters. Those cameras, all those devices, including a cell phone, are in possession of the RCMP. They have a warrant to detain those devices to be used as evidence at a criminal trial. So now that I've pled not guilty, and now that we've fixed a trial date, it's now up to the RCMP to apply for a warrant to search those devices and gather the evidence they need to use at the criminal trial that they seized these devices for. So, how long do you think that's going to take? So, the last update, part 6, we ended on basically the end of the calendar year of 2018. And I wanted to kind of get this video out of the way. And now next video update is going to be January 2019 and what happened in January 2019. So thanks for watching. Stay tuned. This is very far from over. There's going to be some leaps and bounds in the timeline here. So I hope you enjoy so far. Stay tuned. Part 8 should be coming up in about a week. Thanks for watching.